Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy, and we have gathered here to discuss on a very important topic. But before moving on to the topic, it is our routine practice that preamble is recited with a sense of commitment, with a sense of sentiment towards the preamble, because we strongly believe that preamble is our identity and preamble our unity, preamble our goal, and preamble our soul. So therefore I request each one of you to recite preamble along with me. We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. I welcome each one of you to our lecture number 24. Double promotion. Every day we are delivering 2 lectures for the simple reason exams are nearing. Advocate on record examinations are nearing. Therefore, we need to cover all the portions as far as possible to our best of our ability. So we have taken a topic with reference to paper 3, professional ethics. The question is, the title for the topic is, what are the advocate's duty towards the court? What are the advocate's duty towards the court? On a lighter side, before going to this topic, I generally have the habit of attending the farewell functions, swearing in ceremony function, full court reference, or any lectures conducted by any associations. Because we generally say, when we ask a student, where are you from, which college you are from, they say, sir, we are from Lloyd Law College and we belong to, affiliated to CCS, Charan Singh University, or Global University, Christ University. But the education is not within the 4 walls, dear friends. We need to evolve ourselves not only to be a student of a particular university, we should transform to be a student of the university of the universe. When you become a student of the university of the universe, you need not pay any fees. Only thing is, you have to have keen interest. Open your eyes, open your ears. What you want to see, you can see. What you want to hear, you can hear. That is most important. So therefore, when I attended one of the lectures delivered by one of the respected judges of the Honorable Supreme Court, Justice Ravindran, in his lecture series on mediation, alternative dispute resolution, he gave some sort of advice to the young lawyers. See, money is very, very important in the legal profession. There is no doubt about it. Money will save our life. If we have good money, we can get admitted in good hospital. If we have good money, we can engage good senior lawyers. So money is most important. There is no difficulty. But whenever you get cases, it is like a duck laying golden egg. But don't cut it, because it is, though it is laying down eggs, golden eggs, but don't be so greedy to cut it and then try to take all the eggs. You will be treated as a fool. So therefore he says, when there is a case, try to resolve it immediately as early as possible. Therefore through the client's experience, he will tell to many clients that this person is there for speedy disposal of justice, and he is not prolonging the matter for appearance fees or adjournment fees, but he is there to defend the interest of the client. While discussing this, my lord referred to the advocates that we should not dispute three laws. What are they? He asked the question to the audience. One is, you should never fight with my Lord Almighty, who is the creator. My Lord should not be. We are always, we must worship the Lord. We should not fight with my Lord, our creator. That is one Lord. Second Lord is, my Lord judges. A lawyer can always has a right to defend the interest of the client. He can always make a persuasive argument, forcible argument, but still respectful language. You should always maintain the dignity and decorum of the court. So therefore, he cannot act as a mouthpiece for the client. He should always remember that he is also an officer of the court. Therefore, you should never cross the Lakshman Rekha. Therefore, you should never fight with my lords, that is judges. Then we were very curious, who is the next lord? That is landlord, in whose property you are residing. He will evict you when you fight with the landlord. So therefore, these three lords, you should not disturb them or you should not fight with them. On a lighter vein, my lord said, now coming to this duty, advocate's duty, where do you find it? Because many advocates, young lawyers are here. So first and foremost, you should know the origin. The origin of any statute comes from the Constitution of India, which gives power to the Parliament to enact law. As far as this duty is concerned, I would like to draw your attention to Advocates Act 1961. In this case, they have defined who is an advocate. Let me read, dear friends, few provisions. Section 2A of the Advocates Act 1961 defines who is an advocate. Advocate means, section 2, subsection 1A. Advocate means an advocate entered in any role under the provisions of this act. This act means Advocates Act. Then what is the definition of role? ROLL. It is again defined under section 2, subsection 1K. Role means a role of advocates prepared and maintained under this act. So an advocate, it has been defined, and what is role is also defined. State Bar Council of India, everything is defined. Now the most important section is section 49 of the Advocates Act, which empowers, the Advocates Act empowers the Bar Council of India to frame rules. More specifically, let me read, dear friends, section 49, subsection 1C, which deals with general power of the Bar Council of India to make rules. Subsection 1 says, the Bar Council of India may make rules for discharging its functions under this act, and in particular, such rules may prescribe. See, I am reading, the standard of professional conduct and etiquette to be observed by the advocates. The standard of professional conduct and etiquette to be observed by the advocates. So section 49 subsection 1c empowers the Bar Council of India to frame rules with respect to standard of professionals or concerned. Now, by virtue of this, Bar Council of India rules were born through 49. Who is the father and mother? For section 49. Now let me take you to part 6 of Bar Council of India rules. Rules governing advocates, very important. Rules governing advocates, chapter 2. For our today's purposes, I am referring to chapter 2, standards of professional conduct and etiquette. See, there is some expectations from the profession itself. Once you belong to this profession, once you start wearing black coat, white shirt, black coat and gown, I generally tell our friends, to achieve something, we have to sacrifice certain things. At the age of 21, throughout the 21 years of our meditation, as a boon, we have got this uniform. So therefore, when you are wearing this, you must worship. It is not everybody can wear this. This you have earned out of your hard work, out of your payment to the university, and then you have worked hard for 3 years and 5 years, and then you have got enrolled as an advocate. Then only you are entitled to wear this. Therefore, out of your meditation, you have got this. So therefore, worship this. Even I have heard the soldiers, when they lose their loved ones in the fight, they cannot shed their tears, because uniform for the soldier is a bravery, is a courageous one. So there they cannot shed tears, even their own colleague is dead next to them. So that is the respect to their uniform, and they are standing in the borders, and we are also the warrior. Lawyers are the warriors, and we have no barrier. Reason is, we are also fighting for justice. They are fighting against the foreign body from entering. They are protecting the territory. We are protecting within the territory. We are the warriors. And where is the barrier? It is our only this mental status is the barrier. If you say, sir, I cannot deliver a lecture, you cannot deliver. If you say, I can deliver a lecture at United Nations, yes, you can deliver. Reason is, faith in millions of God. When you don't faith in yourself, that means you are an atheist. First, have faith in yourself. The history of the world is the history of few men who had faith in themselves. So you must always have faith in yourself. That is most important. If somebody can do it, others can also do it. The self-confidence, faith, self-respect is most important, dear friends. We are born to live in a palace, but we are standing in the doors and we are thinking that it is a palace. So whose mistake is this? It is our mistake, our thinking mistake. So we have to enlarge our heart, enlarge our mind, enlarge our mental status, and we can grow in this profession. How do you measure your growth in this profession? You can measure your growth depending upon your faith. Your faith in yourself is directly proportional to the growth in your profession. Therefore, that is what Swami Vivekananda has said. Faith in yourself is equivalent to faith in God. When you don't have faith in yourself, that means it is waste. So therefore, dear friends, chapter 2, which deals with standards of professional conduct. What is etiquette? Correct behavior. How to behave in a group. How to behave before the court. We have got different avatars. It is not only the Almighty takes avatar. We take avatar. As a lawyer, you are here. AOR aspirants are here. Interns are there. When we go home, we take different avatars. As a son, as a daughter. When you are traveling in a metro, you take avatar as a passenger. So therefore different avatars, we have to understand our responsibilities. So chapter 2, standards of professional conduct and etiquette. Preamble is most important, dear friends. 65, page number 65 of the Bar Council of India rules, which deals with the preamble. Here what they say is, in the preamble, I will read it for you. In the preamble, once you belong to this profession, noble profession and learned profession, you are always considered to be a gentleman, even not only inside the court but also outside the court. You are always have to maintain your temperament. You should always be a leader. Leader means not to contest in elections, that is also leader. Leader in the sense you lead, you be a role model for others. So always a lawyer is considered to be a role model for other professionals. That is what is expected from us. And what is moral and legal for other community, it may not be moral and legal for us, because more standards are expected from the advocates. So what does it say, the preamble? I am reading the preamble under chapter 2 of part 6 of Bar Council of India rules. An advocate shall, it is not may, shall at all times comfort himself in a manner befitting his status as an officer of the court, a privileged member of the community, and a gentleman, bearing in mind that what may be lawful and moral for a person who is not a member of the bar, or for a member of the bar in his non-professional capacity, may still be improper for an advocate. Without prejudice to the generality of the foregoing obligation, an advocate shall fearlessly uphold the interest of the client. Here they say, of course, we are representing the client to uphold the justice. So you must fearlessly put forth your case, and in his conduct conform to the rules herein after mentioned, both in letter and in spirit. The rules herein after mentioned contain canons of conduct and etiquette adopted as general guide. This is only a general guide. Don't say it is not mentioned there, therefore we can indulge in other activities. It is only a general guide. Apart from that, it is always that you must always act with utmost responsibility. Yet the specific mention thereof shall not be construed as a denial of the existence of other equally imperative, though not specifically mentioned. So when you say that, sir, certain things are not mentioned, doesn't mean that you can indulge in those activities. It is only the guidelines. So what are those guidelines, dear friends? I am just going to read the caption alone, and I have a very interesting case, and they have covered the entire aspects of duty towards the court. I'll be citing very quickly. Here the rule says you must act in a dignified manner. Because very recently, dear friends, Honorable Justice C.T. Ravi Kumar, Judge of the Honorable Supreme Court, in his farewell function, my lords, has cited this. Though judges, we as a judge, we may be sitting opposite to you, but it doesn't mean that we are opposing you. We may also put forth certain points which may in your favor also. So don't think that we are always opposing you. Even judges take a different stand, but we must always that we cannot cross the Lakshman Rekha. We have certain liberty, but at the same time we have got certain restrictions, boundaries. We cannot cross that. So act always in a dignified manner. Respect the court. This is very important, dear friends, because some of them advocates, they loosely use the term that this is not a good court, not a relief oriented, and these judges are manageable. So don't give these sort of comments which is totally unwarranted. Reason is, we are the part of the system. The system is like a glass palace. You are sitting inside and you are throwing a stone at the palace where you are residing. It is going to damage you. So therefore, don't do that. Even within four walls, don't think that I'm all alone or I'm talking only to another person. Even walls can hear you. So therefore, always purify your mind. And you must always remember that you must respectful to the court, because judges may come, judges may go, but the institution must go forever. Because a litigant comes to the court only when he lost his faith, either in the executives, he is already bleeding. Don't further wound him. So that is important. Don't communicate in private with judges. When you're meeting a judge in a party, don't talk anything about a pending case. My lords, my case is there. My lords, what will happen? Don't do that. That is not legal. Refuse to act in an illegal manner towards the opposition. When your client wants some relief, if he is asking you to manage with something, do it in illegal activities. I need a relief. Don't do that. You can reject that brief. It is always a duty of an advocate to accept all the briefs, but provided if you can also refuse to represent client who insist on unfair means. So don't do that. As an officer of the court, you have a duty. Appear in proper dress code. You must always appear in proper dress code, and never refuse to appear in front of relations where you are judge, where judge is your father or any kind of relation that you have. Never appear before that particular judge. Not to wear bands or gown in public places, because we say that this we have earned out of our devotion, and it cannot be worn in public places. And not represent establishments of which he is a member. When there is a dispute with respect to the cooperative society where you are already a member, you should not represent on behalf of the society where you are a member. Not appear in any matters of pecuniary interest. So, and don't stand as a surety for the client. So these are all the duties prescribed under these rules. But let us see how this rules is applicable in a given case. I am going to cite a case. Let me tell you the facts of the case. Facts are quite interesting. How they have behaved with the judge when they did not get proper relief. It was before the Faridabad district court. A magistrate was considering an application for whether to remand the accused to a police custody. That was an application being considered by a magistrate in the Faridabad court. Counsel for the accused, he said, don't remand. But considering hearing the arguments of the state, they have remanded the accused to the police custody. Similarly, the accused and the advocate also appearing for the same accused, they had second application also before the same judge. He was also about to pass the same order. So the counsel became very furious and he said, you know for which order you will pass orders. You are bribed. You are passing orders only after receiving money. And he said, don't behave like this. And there was one senior member was also there, O.P. Sharma. Please guide. He has requested the senior member of the bar to guide this person, younger man. Mr. O.P. Sharma, he said, no, I am a senior member, therefore I can oppose you vehemently. I will side with my advocate colleague. So he also opposed that particular magistrate. And magistrate said, this is not the proper way. Your Advocates Act says you must be respectful to the court. You must always conduct yourself in a dignified manner. But this is not the behavior. Making scandalous allegations, wild allegations. I will report the matter to Chief Judicial Magistrate. Oh, you report a matter to Chief Judicial Magistrate also? We will see him. This was the response. Then ADJ, Additional District Judge, interfered and pacified the advocates. But still they have shouted slogans against those judges. Now the magistrate was really wounded not as a person, but as an institution. When these advocates going to behave in such a way, not in a dignified manner, not in a respectful way, the public will lose faith in the system. So therefore action should be taken. That was a reference, a letter written to the district judge, whereas district judge has forwarded that letter to the Punjab and Haryana High Court. High Court heard the matter, initiated contempt. They punished for nearly 3 to 6 months was the imprisonment, simple imprisonment was given. Now who is aggrieved? These learned advocates were aggrieved. They come to the Supreme Court. Do you know who is their counsel? Mr. Ramjat Malani sir, a learned senior counsel. He appeared on behalf of those advocates. What was the submission made by senior advocate Ram sir? He made a submission, my lords, they have given an affidavit before the division bench of the High Court by tendering unconditional apology. Further, these advocates appeared before the concerned magistrate also, and there also they have tendered apology, and time also have passed. Now it is almost 10 years now. Please don't punish them. Please set aside the order of the High Court. There, the Honorable Supreme Court wanted to decide, anybody can make any wild allegations, commit contempt, they cross the border, Lakshman Rekha, and then they will just file an affidavit by saying, please tender unconditional apology. So the law laid down by the Honorable Supreme Court is this, that unconditional apology should not be accepted. That is a general rule. The exception is, it can be accepted only under exceptional circumstances. Generally, once you commit contempt, it cannot be accepted. You must be punished. That is the law. Now let me refer the judgment, dear friends. 2011, volume 6, Supreme Court cases, page number 86. 2011, volume 6, Supreme Court cases, page number 86. In my humble opinion, if you read this judgment, they have referred many judgments with respect to advocates' duty towards the court. One judgment will cover almost everything. O.P. Sharma and others versus High Court of Punjab and Haryana, comprising of two honorable judges, Honorable Justice P. Sathasivam and Honorable Justice Dr. B.S. Chauhan. So there, the Honorable Supreme Court took the pain to reproduce what they have done. See, what did those learned advocates said before the magistrate? They have reproduced. You have taken bribe. You do all works only after taking bribe. You are indulging in gangism. What can you do to me? You may make contempt against me. I will suck your blood. It has been translated in English. I will suck your blood. I will not leave you till the High Court. You are considering this court as in. Come out. We will just now teach you a taste of judgeship. He is saying, my name is Ellen Prashar. You will come to know today as to how you pass orders against me. He gives his credential. Even earlier, criminal cases are pending against me. Even earlier, he is giving his history. Even earlier, criminal cases are pending against me. If one more case proceeds against me, it would make no difference. It would cause you very clearly to have enmity with me, and now I'll see to it that I suck your blood. If you have any courage, you come out. If you have any courage, you come out. When the magistrate took up another remand paper of the same accused, Mr. Prashar again became furious and uttered that you dismiss this bail application. I have no faith in your court. I am not going to furnish any bail bonds. There is no need for us to have any bail from your court. At that stage, the magistrate asked his reader to call the Chief Judicial Magistrate Faridabad so that situation could be brought under control. On this, Mr. Prashar remarked, "What can your CJM do? You may call him as well. We will see your CJM also. You are indulging in big gangism." Thereafter, the magistrate requested Mr. O.P. Sharma, advocate, who is a senior member of the bar, to request Mr. Prashar to behave properly in the court. However, Mr. O.P. Sharma, advocate, sided with Mr. Prashar and shouted, "We will do like this only. Lock his court, and raise slogans against him." On the asking of Mr. Shri O.P. Sharma, advocate, other advocates accompanying him raised slogans, "Rakesh Singh Murdabad, Rakesh Singh Murdabad." He was also threatened by saying, "You come out, we will see your gangism." When all the officers were sitting in the chamber of the magistrate, they overheard Mr. Prasar shouting in the court in loud voice saying, "You are indulging in gangism. You are passing orders of your choice. The contempt cannot harm me. I will see to it as to how you remain in service. I will see to it how you remain in service." These were the words expressed by the learned advocates. But now, the Honorable Supreme Court is going to decide about the professional conduct and etiquette rules and decisions of this court. The Honorable Supreme Court has held, in the light of the above scenario, before considering the fresh affidavits filed before this court by the appellant advocates, let us recapitulate various earlier order of this court as to the duties of a lawyer towards the court and the society being a member of the legal profession. The role and status of lawyers at the beginning of sovereign and democratic India is accounted as extremely vital in deciding that the nation's administration was to be governed by the rule of law. They were considered intellectuals among the elites of the country and social activists among us the downtrodden. These includes the names of galaxy of lawyers like Mahatma Gandhi, Motilal Nehru, Jawaharlal Nehru, Bullabhai Desai, C. Rajagopalachari, Dr. Rajendra Prasad, Dr. B.R. Ambedkar, who is always here with us, to name a few. The role of lawyers in the framing of the Constitution needs no special mention. In a profession with such a vivid history, it is regretful to say the least to witness instances of the nature of the present kind. Lawyers are the officers of the court in the administration of justice. Thereafter, the Honorable Supreme Court refers to Section 1 of Chapter 2, Part 6, titled Standards of Professional Conduct and Etiquette, which just now I read out. They have elaborately discussed duty of an advocate towards the court. Finally, dear friends, they have referred many cases. Let me quote one or two cases. In Daroga Singh versus B.K. Pandey, at paragraph 19, where the court has held, the courts cannot be compelled to give command orders. The act committed amounts to deliberate interference with the discharge of duty of a judicial officer by intimidation, apart from scandalizing and lowering the dignity of the court, and interference with the administration of justice. The effect of such an act is not confined to a particular court or a district. This is very important. Such scandalous allegations making against a particular magistrate, it is not only against that particular magistrate or the district or a state. It has the tendency to affect the entire judiciary in the country. It is a dangerous trend such a trend has to be curbed. If, for passing judicial orders to the annoyance of the police, the presiding officers of the courts are to be assaulted and humiliated, the judicial system in the country would collapse. Likewise, dear friends, one more case, R.D. Saxena versus Balram Prasad Sharma. The court held as follows: in our country, admittedly, a social duty is cast upon the legal profession to show the people beckoned light by their conduct and actions. The poor, uneducated, and exploited mass of the people need a helping hand from the legal profession. So, therefore, making scandalous allegations against judges, and that is not at all advisable, and that is illegal, and we are crossing our borders where it might end up in the contempt. And now the court has asked, what about our freedom of speech and expression? They say, indeed, no lawyer or litigant can be permitted to prohibit the court or malign the presiding officer with a view to get a favorable order. You can make a request, you can argue your case, both merits as well as on sympathy also you can argue, but you cannot prohibit a judge and then get an order. Judges shall not be able to perform their duties freely and fairly if such activities were permitted, and the result of administration of justice would become a casualty and the rule of law would receive a setback. The judges are obligated to decide cases impartially and without any fear or favor. Lawyers and litigants cannot be allowed to terrorize or intimidate judges with a view to secure orders which they want. This is a basic and fundamental, and no civilized system of administration of justice can permit it. So, therefore, in this case, they have beautifully explained what is expected from the professionals. Finally, what had happened? The climax. Whether Mr. O.P. Sharma and Mr. Prasad, what happened to those learned advocates? The answer lies here, dear friends. After discussing many judgments, the affidavit was given. A new affidavit was given, filed before the Supreme Court. What does it say? I, so and so, aged 61 years, senior member. He says that the deponent is one of the appellants in the above mentioned appeal. That the deponent has the highest abiding faith in the institution of judiciary and cannot imagine saying or doing anything which would undermine the dignity and prestige of the institution. This is after the enlightened soul. After becoming Buddha, they have come out with an affidavit by saying, I can't even imagine that whether, how can I undermine my own institution. Thereafter, para number 3, that the deponent hereby tenders unconditional apology before this honorable court for the incident which took place in the court at Faridabad, out of which this contempt proceedings arise, and further undertake to maintain a good behavior in future. That at the first available opportunity, the unconditional apology and undertaking for maintaining good behavior was filed before the learned magistrate. Then it was signed by the deponents. Similarly, it was signed by all the learned advocates. Ultimately, the Honorable Supreme Court has laid down a law here. A court be that of a magistrate. A court is always a court. A court be that of a magistrate or the Supreme Court is sacrosanct. The integrity and sanctity of an institution which has bestowed upon itself the responsibility of dispensing justice is ought to be maintained. All the functionaries, be it advocates, judges, and the rest of the staff, ought to act in accordance with moral and ethics. Finally, the honorable judges has said, in light of the above discussions and reasons which we have noted in the earlier paras, and as an exception to the general rule, we accept the unconditional apology tendered in the form of affidavits in terms of the proviso to section 12 subsection 1 of the Act, and discharge all the appellants. We hope and trust, this is very, very important. We hope and trust that the entire legal fraternity would set an example for other professionals by adhering to all the above mentioned principles. So, with this, the Honorable Supreme Court has accepted their apology and they said don't indulge like this unethical activities in future. Thank you so much, dear friends, for your patience hearing. Truly honored to present.
They have two more interesting cases.
Yes.
Mishra and R.K. Anand and
Absolutely, it is all discussed in this case. I take this opportunity to deliver two books for one of my associates. I request our Shankar sir, younger member of the bar. Yes, please come. Yesterday was sir's birthday, and sir is committed, devoted, and now he is going to write an AOR examination. He has truly become a student of University of the Universe. So for him, I am presenting this book on behalf of all. Before Memory Fades, an autobiography by Mr. Senior Advocate Fali S. Nariman. Please have this. Accept. Thank you so much, sir. We are grateful, sir. And thank you, sir. Thank you. And Advocate on Record Aspirants Academy, though it is being conducted within the four walls, how it reaches the other states because of our YouTube channel. And who is the backbone of that YouTube channel is Mr. Tegchand, my esteemed associate. Please come. Yesterday was Nani Palkiwala's birthday. A great jurist who had a stammering problem in the beginning when he was a child. But thereafter he became a great jurist and great legal luminary in our legal profession, where art of advocacy is a part of our skill. So therefore any challenges we can overcome through our devotion. And I have requested him, please read history of Nani Palkiwala to make history. So this is my humble gift to you, Tegchand. Nani Palkiwala, the courtroom genius. Thank you so much. Yes, now you can ask questions, sir. Yes, now the question. Any?
So my question is,
Yes.
a matter is coming from Honorable Allahabad High Court to Supreme Court, Article 136 invoked in limine dismissal. Is the question was still open? If the similar issue is before Madras High Court, can a counsel take a pleading before Madras High Court by saying that this issue has been settled because the Supreme Court has dismissed this in limine?
No. When it is dismissed in limine, the meaning is very, very clear that the Honorable Supreme Court has said that it is not a fit case to interfere, or it is not a fit case to invoke our discretion. Therefore, no law is settled here. Therefore, that plea cannot be taken in the Madras High Court.
Question law is still open.
Absolutely, absolutely. Thank you so much. Thank you.